Yes, start.
Your Lordship, we filed the notes which were handed over on the last occasion.
Where is he, Mr. Sibal? She's supplementing.
He's on his legs, Your Lordship. He's on his way.
He's on his way. 15 minutes we have told that only. So you start now.
Chapter 1, Your Lordship, page 1 of the written submissions.
Submissions on behalf of the petitioner, West Bengal, correct?
Yes, Your Lordship.
Kunal Mimani, yes.
He's the advocate on record, Your Lordship.
Okay.
Yes.
Yes. What's your good name?
Your Lordship, Mahima Cholera.
Mahima?
Cholera.
Are you with Mr. Sibal or are you with independently in this brief?
Independently with the law firm, Your Lordship.
Which law
firm? Your Lordship, Fox and Mandal.
Okay. Yes, please proceed.
Yes, Your Lordship. Chapter 1. Whether in the Indian federal structure, each and every state in the country is constitutionally or even otherwise legally obliged to match rates of dearness allowance for corresponding periods as that fixed by the central government. Constitutional framework. The constitutional position in respect of aligning the payment of dearness allowance by the Union of India with the DA paid by any state government is the question for determination. It is a settled position of law that payment and the rate of payment of DA at the level of the central government is at its discretion, since workers to whom DA is to be paid needs to be cushioned because of the rate of inflation which is stipulated by the All India Consumer Price of the central government. Entry 70 of List 1 of the 7th Schedule of the Constitution refers to Union Public Service Employees, All India Services, Union Public Service Commission.
This Mr. Sibal has already argued.
Yes, Your Lordship. So, Your Lordship, I can skip to para 7.
Yes.
A mandamus seeking DA at a rate that is separate from the notifications issued by the state is not available to the employees because they seek to demand more than what they are entitled to in law. Therefore, this Honorable Court has to decide the basic question whether on the basis of the notifications issued by the state government, it has committed to paying the DA with reference to the AICPI. It is submitted that there is nothing in the notifications to suggest the same. Your Lordship, the notifications mentioned here are the ones available at page 168 onwards.
Yes.
The AICPI only stipulates the rise in the rate of inflation on a monthly basis, which is taken into consideration by the central government on the basis of the explicit recommendations of the 6th Pay Commission to fix the rate of DA. That is the exclusive right of the central government.
Mr. Ahmadi, she is doing a very good job.
Yes.
Yes, continue.
If the central government were to issue a circular that all payments by the states of dearness allowance must mandatorily conform to the AICPI, such a circular would be per se unconstitutional. Therefore, no court can issue a mandamus for calculating the rate of DA on the basis of the calculation reflected in the AICPI unless the state governments explicitly state so in their notifications. In our case, Your Lordship, our notification does not have such a statement. The intent of the state government of West Bengal in issuing the notifications is reflected from the contents of such notifications by which it fixed its own rate of DA. It is submitted that the state government had no intention of following the central rate of DA, and hence the notifications themselves issued from time to time have no reference to it. Hence, the state government has demonstrated its intent that there was no commitment to follow the AICPI. On the other hand, there is no challenge to the different notifications containing the rates of DA declared by the state from time to time in any of the courts below, and neither have they been set aside either by the tribunal or the High Court.
Yes.
The attempt of the respondents is to suggest through a process of interpretation that even though there is no explicit commitment, in fact, the intention is to the contrary. In the various memorandums, the Honorable Court must read into it a commitment on the basis that the whole purpose of the AICPI is to protect the salary of the employees and to cushion them on the basis of inflation. What the law does not permit directly cannot be done indirectly. The rate at which the DA is to be given by the state government is based on several factors, including its fiscal position, priorities, and capacities, which differ from state to state. The employees of the state government, in fact, have been given benefits which employees of the central government are not given. Your Lordship may note that details of these benefits are at paragraph 11 and 12 of our application.
Yes.
All these factors have to be considered, which are to be determined by the state government. Hence, a proposition of law that leaves no discretion in the hands of the state government would fall foul of the constitutional scheme. The Parliament or Union Executive may legislate or issue executive directions on matters within the exclusive domain of the state legislature or executive under Article 252 and 73 only, with consent of the state concerned, not unilaterally.
Correct.
Accordingly, imposing the AICPI, published and revised under the Union Ministry of Labour and Employment, for determining dearness allowance payable by state to its employees without such consent encroaches upon the exclusive domain of the state and is therefore unconstitutional.
Very well.
It would, in essence, amount to an abdication by the state of West Bengal of its legislative and executive functions in perpetuity in respect of subject matters over which it possesses exclusive domain. By mechanical linking of the rates of DA to the AICPI, which is published by the Ministry of Labour, Employment, Government of India, the state would divest itself of all control and discretion in fixation of dearness allowance and would instead be irreversibly bound by the AICPI as and when published by the ministry.
Yes.
Your Lordship, if Mr. Ahmadi...
Mr. Ahmadi already concluded. You are arguing so well, you're getting an opportunity. Please proceed.
And we may not allow Mr. Sibal to argue hence. If we have already completed, because we had thought of allowing 15 minutes to each.
Yes, sir.
So that we conclude today.
Yes, sir.
We will finish after. See, repetition of the same thing.
Yes, we'll not be placing. Supreme Court
Mr. Bhattacharya,
issue.
the young council getting an
I
opportunity.
place it
We are
on the
the court is allowing.
Let it place it.
We also see. My lord has already said it was Mr. Sibal was not here. We had only one option. Thank you very much. Young council, we are just waiting.
Yes,
My
yes.
lord has clarified. If Mr. Sibal comes, he will only sit beside her.
welcome her, and if she is doing so well, let her place it. I don't mind, I'm happy.
Mr. Sibal has to share today's whatever.
Supreme Court's view on the issue.
Yes.
Para 15. This issue has already been settled once by this court in the case of Tamil Nadu Electricity Board. It's part of the compilation of judgments which we had
We have
read.
seen that we have seen.
Yes.
Yes.
Similarly, para 16 also refers to 3 judgments
We have
which are
seen
part of the
that we have-
compilation. Yes. 100% inflation neutralization. Para 17. The dearness allowance calculated by the central government is 100% neutralization of inflation. However, we submit that there is no mandate to do so by the state and neither is it advisable as has been settled by the Supreme Court. In the case of Kamani metals, Your Lordship,
Yes.
it can also not be said that if 100% inflation is not being neutralized, such action is arbitrary. Thus, partial neutralization of inflation by the state while fixing dearness allowance after taking into account various other factors is non-arbitrary exercise of discretion.
Very good.
Your Lordship, if we may turn to para 22 at page 9.
Yes.
We have listed 12 states apart from the state of West Bengal.
Who do not follow central government rules.
Yes, Your Lordship.
Correct.
And a table is also provided at Appendix 1.
Yes. Very good.
Your Lordship, at page 10, there are two tables which we have summarized for your convenience. The first table deals with 4 states being Chhattisgarh, Himachal, Meghalaya and Sikkim,
Yes.
which have pari-materia rule regarding the definition of existing emoluments.
Yes.
In the event, this,
Read the dictionary.
yes, if I may also read the definition for Chhattisgarh, 3E, which is the relevant rule for Chhattisgarh, means the sum of existing basic pay and existing dearness allowance at index average as on 1st day of January 2016.
Yes.
Similarly, Himachal Pradesh,
Yes.
existing emoluments means basic pay plus dearness allowance appropriate to basic pay admissible at AICPI average of 1510, because the scale referred there is
What is the
90.
language in other states?
Yes.
These 4 states are in.
These 4 states, Your Lordship, are
Other states.
other states, Your
Who are
Lordship.
granting on central basis.
No.
The ones which are granting on central government. Your Lordship, we will have to check that once. But we are definitely not in, we'll have to check that, Your Lordship. We
If
can,
the language is the same there also, then what happens?
yes, Your Lordship. So, the language in the
Is
rule,
there any judgment of Supreme Court which
Yes.
deals with these AICPI issues?
AICPI issued. So, Your Lordship, there are judgments which deal with neutralization of inflation for the purpose of calculating dearness allowance and salary, which is Kamani metals. We will have to check whether there's anything specific to AICPI index.
Specific to, because we are specific on AICPI.
Yes, Your Lordship.
This whole litigation is about AICPI.
Yes, Your Lordship.
Is there any judgment of Supreme Court which deals with this, whether this index average should be read on the basis of AICPI or your own state's understanding of index average or inflation?
So, Your Lordship, with respect to your second query, state's discretion has
We
been
have to
upheld.
decide
Yes.
for all the states.
Yes, Your Lordship.
It seems.
Yes,
will
Your
be
Lordship.
applicable. Will not decide, but the law will be applicable.
Absolutely, Your Lordship.
So today you are West Bengal. Tomorrow some other states say we have evolved our own index average methodology, which is still less than what you are granting.
Yes, Your Lordship.
Or more. Or more.
And with respect to your query on state's discretion being upheld for dearness allowance, the Tamil Nadu judgment has clarified that, but we'll check regarding AIC.
Read the para page 6.
Page 15.
Page 6.
Your Lordship, if I may just read the excerpt from the Tamil Nadu judgment at para 15, page 6. There is no rule or obligation on the state government to always adopt the dearness allowance as revised by the central government. Your Lordship, this itself clarifies and settles the issue that there is no obligation on the state to follow the AICPI, because it is a admitted position that the central government follows the AICPI. It is absolutely not necessary for the state government to adopt the dearness allowance rates fixed by the central government. It should be looked from the financial position of the state to adopt its own rates or revised rates of dearness allowance.
Yes.
Your Lordship, if I may now place the table which starts at page 12.
Yes.
So, Your Lordship, the first table essentially set out those states where the definition of existing emoluments was similar, and our submission to that regard is that in the event this court is inclined to hold that there is an inbuilt in ROPA 2009 an implicit formula for increasing DA rates linked to AICPI basis this definition, these 4 states will get affected.
Correct.
And similarly, Your Lordship, the second table, in the event we are to leave aside this definition, and this honorable court holds that even without an explicit and implicit formula in the relevant ROPA, the basis or discretion of the state government to fix the rates of DA for its own employees should only be guided by and or 100% linked to the sliding AICPI index, which is the central government rate, without any discretion of the states. The following additional 7 states which do not follow the central DA rates also get adversely affected.
Yes.
Your Lordship, the factual matrix has already been placed by Mr. Diwan.
Now kindly come to page 40, the factual clarification.
Yes, Your Lordship. Your Lordship, these factual clarifications were placed by Mr. Diwan in his rejoinder.
That's right.
Yes.
And therefore, you kindly come to 43 additional points.
Yes, Your Lordship. That's
43
yes, Your Lordship.
additional points.
Para 70. The upshot of the submissions of the respondents has been that it is explicit, if not at least implicit from ROPA 2009, that state of West Bengal is obliged legally to follow the AICPI published from time to time while declaring rates of DA. This argument is, however, belied from the tribunal's order itself, which you may kindly see at para 33 and 37 at volume 2, page 484.
Yes.
That it is the bounden duty of the state government to evolve norms, principles for payment of DA to its employees by calculating the same on the basis of AICPI published from time to time. It was on this basis that the Chief Secretary of the state was directed to evolve norms and
That
principles.
we have seen now. Delay and latches, what do you say?
Your Lordship, the period that we are concerned with is between April 2008 to December
If
2019.
it is in their right and entitlement, suppose, then where is the question of delay and latches?
Yes, Your Lordship, if there is a question of right and entitlement, there is the only reason we've included this point is to describe the unreasonable time that they took to approach the court.
Thank you. So that's it. Thank you very much.
Grateful, Your Lordship.
So this side is over now. Please.
My lords, we'll restrict our submissions to.
We'll request you. The कागज दीजिएगा, madam. We'll just request you. Say, true to her word, she's not taken more than 15 minutes.
Yes.
If in 10 minutes each one of you wish to conclude.
We don't need long.
Just one thing, the AICPI aspect is dealt with us from page 35. Your Lordship will see.
You've seen that. Is there anything, see, what is it new that they've argued for you to rejoin?
Yes, my lords. That's what we have restricted our submissions to. Please just hand over the short note.
Brief week in 5 minutes because
We'll keep it
you
short.
are arguing to the rejoinder,
Yes.
responding to the rejoinder.
See, what we'll do is, we'll go through your submissions, rest assured, we'll go through the submissions of
Yes.
every word written there.
Don't read the submission.
If there's anything you wish to add orally, please do that. Otherwise,
My lords, I'll add orally, but I'll only take my lords to the parts that are directly.
We'll go through it. Don't
Yes.
worry.
My lords, Mr. Diwan argued first, in the first round, that the citation of the AICPI in ROPA 2009 was static. What does that mean? That leads us, my lords, to the somewhat absurd conclusion that the citation of AICPI 536 with reference to the series that 1982 is equal to 100 is only true for what they call the existing emoluments, that is 1 month. 1 month. So it would lead us to the conclusion that that index is only applicable for the month in which the ROPA rules were passed, and then that's it. Having heard, having our arguments having come in counter, my friends then argued, my learned friends then argued, I think it was Mr. Divan, that no, now it is a hybrid. So they said that there is that static AICPI, but then after that, there are memoranda that come in, if my lords recall, where the state of West Bengal exercises its discretion in the memoranda. My lords, if I may ask, is that a fair encapsulation of the argument? I'm grateful.
No, we are not saying anything. So we are not saying anything.
My lords, the difficulty is this, that the Constitution doesn't allow it. Article 309 is perfectly crystal clear. And what Article 309 says, and only for this purpose, if I may refer to para 2 of my submissions. It states that absent an act of the state legislature, the recruitment and conditions of service of a person serving the union or the state shall be in the competence of the governor of the state or such person as he may direct in connection with the affairs of the state, and I quote, to make rules regulating the recruitment and the conditions of service of persons appointed to such services in force until provision in that behalf is made by or under an act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act.
No, we'll request you not to read, please. You just highlight the new points which you wish.
So this is the point I'm
What you
making.
have said that there was a dramatic shift in the arguments. We have taken note of that. That it is static or non-static is one thing which you say. To what is your response to that? It is static or non-static?
My lords, the point that I'm making is that the rules have to have a complete answer.
Okay.
That you can't have the conditions of service regulated in the memoranda, because what the Constitution says in Article 309, that you must have it either the conditions of service, including DA. No, it's nobody's case that DA is not a condition of service. So therefore, such conditions of service must either be in the act of a legislature or it must be in a rule.
So therefore, what you are saying is it is there in the act and the rule itself, and not the memorandum. That's simple as that.
It's as simple as that.
Point well taken, ma'am. What else?
My lords, this I need not go into because my lords are well aware of these judgments. That rules override memoranda. You have Ajay Kumar Das, you have Ashokram versus the state of Maharashtra, you have Bank of Baroda versus Palani, you have, so this is all established. And my lords, when I say that the state has made dramatic shifts in arguments, I don't say this on the basis of just this hearing. I say this on the basis of a litigation that has carried on for 20 years.
Correct.
So the Advocate General, for example, the learned Advocate General of the state of West Bengal, had said that it is ad hoc. That it is being decided in an ad hoc way, yes, but it is because we are deciding it on the basis of the funds we have.
Very well.
Financial consideration, paucity of funds. Again, my lords have on a number of occasions said that paucity of funds is no excuse.
The right is there, it has to be, it's complete.
Precisely. Now, my lords, the statutory scheme in ROPA I have set out in the third part. And the reason I have set it out is because there will be an attempt to say to my lords that this is a very big matter. It has pan-India applications, etc. My lords,
It's a big matter, therefore you are appearing.
if only. We are on sorts of matters. At this stage. My lords, the thing is that any decision of my lords has pan-India implications. This particular matter is restricted to this particular rule and the manner in which it is phrased.
Very well, very well.
Now, what my young learned friend had just argued, and in fact, some people before her had also argued, I believe Mr. Diman had also argued it. They said that, look, we cannot follow the central government rules. This is not something that's binding on us. That we cannot make good 100% of the inflation that is occurring. Now, my lords, with the greatest respect, this is a straw man. This is an argument that is not in the room. A bit like my learned senior Mr. Sibyl. Nobody has made the argument that we should follow the central government rule. We are saying that the state of West Bengal, having enacted the rule, which happens to be identical to the central government rule, identical in its phrasing, in its reference to the ICPI, that they must follow that rule. You've made the rule, you follow that rule. So therefore, my part 4 refers to the state is arbitrarily
That we
applied.
have seen 1, 2, 3, 4 parts very beautifully. Now you can come to your part 5, please. Part 5 says that they themselves are following AICP, so therefore they are bound to follow it. That's it.
My lords, what I am demonstrating here is that they had consistently, until 2010, explicitly exercised their own constitutional jurisdiction to adopt and follow the central government.
So therefore, your right emanates from this.
So therefore, the fact that they then started following, citing the central government rates, that's where my right emanates from, the 2009 rules. The arbitrary manner in which they suddenly said that this memoranda now occupies the field is something that doesn't even go with their earlier practice.
But then you have not answered that you have not challenged the memoranda.
My lords, with the greatest respect, the memoranda argument was made for the first time in this court after everything was filed. And I have set out what the state had argued before the tribunal.
Have your breath, Mr. Sibbal, don't worry. Have your breath, have your breath.
Sorry.
No, Prophet. Yes.
My lords, before the tribunal, before the High Court in 2018, where the High Court said that due to the fact that the state government has adopted the 2009 rules, that it is now a legal right, and that matter, if I may, that principle, if I may again remind my lords, is now raised judicata. It was decided in 2018. So now to say, having argued throughout paucity of funds, financial incapacity, we have discretion, to now say that there are all these memorandums that actually have the answer, and that create some kind of valid legal right, having not, my lords, challenged the 2018 judgment. Now, after all these years, my lords, just to refer very briefly to my earlier submissions, that perhaps,
You need not refer to that. We have already heard your address.
but to wrap up,
Don't worry, we'll go through it. Every letter which is written there, we'll wait. Don't worry.
my lords, Kerala's example is illuminating. Why? Because there are many other states that some of which follow the AICPI, some of which don't. But for example, you have the state of Kerala. They do not follow the AICPI, they have their own consumer price index. And they have exercised their discretion under 309 by enacting rules that have a basis in Article 14. Having adopted the rules
Yes.
pursuant to Article 309, it does not lie with the state of West Bengal at all. To say that now we are passing memoranda on the basis of our whims and fancies, which now give us the right to take away your vested rights.
Very good. Thank you.
I'm so grateful.
Anyone else this side? Yes, Mr. Bhattacharya.
Remember, the basic issue is very simple. This is no question.
Just one.
Sorry, if you want, you can sit here. Sorry. Yeah.